Under the circumstances of this case, and based on the language of this paragraph, these witnesses are not suspects. These people, these potential witnesses, cannot say there is a reasonable possibility of exposure to prosecution or involvement in a crime by reason of a responsive answer. For those reasons, I find that the subpoenas are enforceable and these witnesses must testify.
Martin's ex-wife, Joan Harmon, factors into trial strategy for both sides in this case. For the state's case, she's tied to the alleged motive. Kit Martin and Joan Harmon were going through a contentious divorce at the time of the murders. Harmon got the court-martial trial case rolling, claiming that Martin mishandled classified documents and sexually abused her and her children. Now, one of the victims, Cal Phillips, was helping Harmon leave Martin and was preparing to testify at the court-martial hearing scheduled 2 weeks after his murder. But for the defense, Harmon and her son posed the possibility of other suspects in the killings. So if they were forced to testify, it could allow the defense to direct blame at them. Now, the judge ruled that they do not have to testify, but Harmon and her son's attorney kept pushing to quash the subpoenas. In a shocking turn of events, the attorneys prevailed, and they convinced the judge to reverse that initial ruling. Let's listen.
I don't think Ms. Harmon would have any problem answering the questions of the Commonwealth, but this is not a situation where she gets to choose what she can answer and what she doesn't answer. Based on what has already been presented to me expressly from Mr. Griffiths today, I cannot advise her to take the stand on her own. I am advising her to invoke, and so she is, and I have no reason to doubt that she is not under the proper legal right to invoke such a right.
It's Justin Elijah, Your Honor, and I think Justin is what he goes by, and some people call him Elijah, but I've always called him Justin.
All right, and based on your consultation with him, what is your position in regards to the invocation of the Fifth Amendment?
And he will be invoking that right against all questioning, Your Honor, not to specific questions, but to all questions.
Neither witness has grounds to invoke the Fifth Amendment. Neither witness was ever advised of their rights when interviewed by law enforcement. Neither witness has ever made a statement incriminating himself. A mere allegation by a defendant that a particular person is an alternative perpetrator does not lead to that person being able to invoke Fifth Amendment privilege.
Our position is that we have the right to compulsory process under the Sixth Amendment, Section 11 of the Kentucky Constitution, and we have a right to a fair trial under both of those as well. We served subpoenas on her. We want her to testify in trial, and we would object to her being able to, and I shouldn't make it just about her or Justin being able to take the fifth judge.
That extrapolation of this ruling changes my mind. I'm going to quash the subpoenas and allow the witnesses to invoke the Fifth Amendment.
That was fascinating to watch. Let's bring back in my guest, criminal defense attorney Charlie Rickers, to talk about this decision because it really does affect the trajectory of both the prosecution's case and the defense case, because Joan Harmon is a key witness really for both sides. We know the prosecution wants to bring her in to show that she had nothing to do with this, but the defense wants to bring her in to say, hey, she could be responsible in this case.
Sounds like a big witness, Chanley, I think that her testimony could sway the outcome in the case. It's an interesting point that the judge had originally decided that she has to testify and now says that she does not have to testify. It sounds like her attorneys are more worried about the questioning that the defense will inquire from her, and that's why the judge is now saying that she doesn't have to testify. I think it will be very interesting, and I think it is admissible at the end of this case, in closing arguments, when the defense has an opportunity to talk to the jury and tell them that this woman pled the fifth and did not want to answer because she could incriminate herself in these murders. And you can make a lot of arguments that are justifiable as a result of this woman not taking the stand because she is worried about incriminating herself if you're a defense attorney standing up and giving closing arguments in this case.
Absolutely. And the reasoning, let's talk a little bit about the reasoning the judge used. Like you said, he originally said, no, she must testify because here it was a unique situation where the prosecution and the defense both agreed that she should testify, that she really didn't have a right to invoke her Fifth Amendment. She was never a suspect in the case. She was never Mirandized previously in the case, and they wouldn't implicate her. None of her answers indicated that previously. But yet it was her attorney who, after the judge originally ruled she must testify, said, no, Judge, please go back and read the full case. It was Knight v. Young case there. And once he took the time to do that, he said, actually, no, you are correct. So I think that would said a lot about this judge to go back and make sure he made the right decision in that moment.
That is true, Chanley, and you have to respect the fact that, this is a case that has garnered a lot of national publicity, and judges and prosecutors and defense attorneys, are a bit on edge, a little bit more than they otherwise would be without the cameras. And it shows that the judge, like pretty much every judge I've ever been in front of, wants to make sure that the decision that he or she makes is the best and is in line with the law. And the judge was willing to reconsider his opinion and believes that it's appropriate that she's entitled to take the Fifth Amendment. And that's a good sign that this judge is taking the law and his role very seriously.
Absolutely. Thank you so much for offering your insights, Charlie. We're going to keep you around. And we're going to talk about Robert Durst next.